Hello, good afternoon. Today, I would like to finish up my lecture series on course of product development, being our last chapter titling Patents and Intellectual Property, Chapter 12. So, this is to finish up the syllabus of 12 chapters in product development course. Okay, in this chapter, basically it discusses about what it takes to create patents and how to file your intellectual property, and those are very much related to uh, intellectual property topics that are very much relevant in current modern days. Current modern days, in this legal issue of technology and patents, and this development is actually must be aware of by many technology management students, including product development course student. So I think current legal issues pertaining on technology and patent, which is hot in the news right now, is pertaining to the battle trade between the United States and China. So since the past 1 or 2 years ago, so the friction between two nations in trade has been very dramatic and heated debate in many news. So I would like to cover this scenario in terms of technology and patent issue as far as related to international trade. So this battle started when the United States imposed trade tariff to China export the product to the mainland America. So when the trade tariff begins, so it is followed by another episode in which that Google banned some of their software product, like partly those based on Android platform, and also those apps in Google Play can no longer be accessed by Huawei smartphone users. So their major concern on this technology patent and intellectual property issues actually deepen with the growing dominance of 5G infrastructure, network and communication technology controlled or developed or pioneered by China actually. So Huawei being the one of the biggest telecommunication company from China has been setting up the standard and international protocol for 5G communication. So by then, is it really national security issue for the US? From the US perspective, it was seen as a kind of technology race between China and United States. And if China managed to uh, install their 5G infrastructure and standard in many parts of the world, China perhaps becomes the technological protocol controller for this 5G infrastructure. As such, the United States will feel insecure due to this lagging behind 5G infrastructure development by China. So US felt their national security is being threatened. And the United States state government blame that China company relay information or submit information to Chinese government, which is primarily Communist China Party. So the issue is either patent or intellectual property has been really breached as far as the control is concerned that contribute to national security for many countries which uses Huawei infrastructure IT technology. So trade tariff is just a means of getting it kind of a tug and war between the two countries that are having friction as far as balanced trade. So this trade tariff issue is not new in the global international business, because in the previous movement, many countries, including the G7 countries, they promote free trade between countries in the name of APEC. Asia Pacific Economic Cooperation. It is an agreement between many countries in Asia, particularly in the eastern part of Asia, like Russia, China, Japan, South Korea, Thailand, Malaysia, Indonesia, Australia, and New Zealand. They have a trade agreement with the United States, Canada, and also Chile and Mexico, that they're going to have a free trade, import and export of goods without any engagement of a tariff. Tariff is actually an additional tax that exporter must pay in order to send their goods to the exporting country. So as such, it will contribute to additional cost of exporting from one country to another country. So APEC is to promote free import and export trade business, basically without tariff. So by having this kind of bat, trade battle between the United States and China, so it actually defeats the purpose of agreement agreed previously by many countries in Eastern Asia, especially, and with the continental Northern America and South America. So the argument is that is the trade tariff is a legal argument, whether China does steal or illicitly tapping technology from United States, or stealing patent or intellectual property from the American company and later being copied into Chinese product. So that is still highly debated, this issue, whether it is proven to be truly a real case or it is just merely a blame. So we at the technology management student, we must be aware that this kind of issue is either highly political or is it truly technology and intellectual property issue that has been stolen from one country to another country. So in my proposition is that so far the United States Court has never bring a true single case of intellectual property theft by Huawei in American court. So it is so far merely a political issue. In such a way, even the United States began to feel that this trade tariff tug of war has been losing in the American perspective. So China has gained very much upper hand on the trade tariff tug of war with the United States. And even the American business leader agreed that this trade tariff is very unproductive for international business. So this is the current legal issue on technology and patent pertaining to American government and also with Chinese companies and Chinese government. So let's move on the what is the actual issue on intellectual property, why it is so valuable, right? Why it is being closely monitored, why it is being so much monitored in such a way it is an important asset for many companies. Actual property is actually can be seen as an intangible asset. It is something in a non-physical appearance. It could be in the digital form, or it could be in the form of document, file, procedure, process that is created by the inventor in order to show their creation of product, process, and so on. So there are many types of IP, intellectual property. It can be translated into trademarks, copyright, design, software, patent, trade secret, formula, industrial recipe, and so on. Those are considered intellectual property. Intellectual property actually carry very big value for many companies. And many big companies, for example, those Fortune 500 firms, actually have the value of IP range between 45% to 75% of the total asset, which is intellectual property in the form of patent, copyright, design is very, very much valuable by international company. For example, the real value of intellectual property with perspective of companies can be seen like in Malaysia setting in 1996, in which during those time our national car company Proton was seeking an international partner. So they are searching for potential another foreign automobile maker to team up with Proton. In those days, it is quite limited choice for companies to team up with Proton, particularly the brand from Europe. So there are two brands from Europe that are potential or quite interested to seek joint venture collaboration with Proton in 1990s, 96. One example is one example was Mercedes-Benz from the Daimler Group. Another candidate is Renault of France. So during evaluation by Mercedes-Benz whether to joint venture with a Proton to manufacture automobile in Asia, automobile Mercedes automobile company find that Proton has a very low intellectual property ownership. So as such, Mercedes-Benz reject to do joint venture with Proton because of its low level of intellectual property ownership by the patent office. So after quite a while for searching, ultimately Proton could find one European partner by the name of Renault of France to join with Proton to co-produce car in ASEAN market. So ultimately, in 1996, they managed to produce the first model car in the form of Proton Tiara. And Proton Tiara, after a few years of sales, didn't produce uh, significant big sales for Proton. And Proton Tiara was actually not a successful model in Asia, Malaysia, and also at Proton sales performance. So it is just considered average or low sales group for this model Tiara car. So that is how the valuable of intellectual property in the eyes of beholder, because the more the higher intellectual property that you have within your company, actually the higher value of your company in the perspective of your competitor or in the perspective uh, of your comparative companies in the same industry. There are a few types of intellectual property that has been discussed in the textbook. Intellectual property could be translated in the form of utility or patent. For example, patent utility for transferring data in the form of format like USB, universal serial bus format. So this kind of patent utility emphasize on its novelty, means its uniqueness, usefulness in terms of its broad format as far as data transfer format is concerned, and it is requiring formal application in order to apply Python under this utility category. The other type of intellectual property is in the form of design patent. Design pattern could be explained in the form like this shape of Coca-Cola glass bottle. So this shape is just kind of slightly slender on the bottom and slightly bigger on the top and slightly bigger on the base is actually a patented design by Coca-Cola. So the design is very significant to Coca-Cola in the form of ornamental design category. So next intellectual property category, the third one is a plant patent. You know that plant can be genetically patented because during uh, these modern days, many plants are genetically engineered in the form of its final product, in the form of its color, in the form of its production output, in the form of like this grape. So could be genetically engineered without seed. It becomes seedless grapes, and it is a patented uh, type of plants. So this is under category new composition of the matter or new composition of species of plants. Intellectual property can also be translated into trademarks. So it is a mark for doing trade. For example, this Nike swoosh trademark is distinctively belong to Nike Shoes Corporation. So this trademark in the category of word or symbol belong to very specific product belonging to specific companies, and this must be registered by the company in order to use this symbol. The fifth type of intellectual property is categorized under copyright. Copyright normally in the form of like books, digital media, music. Those are considered original expression of works in the form of copyright. So this kind of copyright also need to be registered. And last but not least, among the last category of intellectual property is trade secret. Trade secret is considered under proprietary, and that information is useful, and it may not be needed to register. Trade secret in the form of formulation for particular food, formulation of particular drinks, a particular kind of recipe. Those are considered confidential for the companies, and you can file it under trade secret, and it is proprietary and very valuable. Those are six types of intellectual property that has been described in the book. So specifically, let's take a look on each of them in the form. First one, trademark. Trademark is basically the name translates itself mark for doing trade. So normally, many product in this modern industrial age, they mark their product with a particular symbol, acronym, shape, or certain entity to state the mark of its product. For example, IBM is traded mark with character I, B, and M. It stands for International Business Machines. And IBM also produced many or variety various models in their notebook, in their computers, and one of their uh, trademark, basic or product mark is called ThinkPad. So this is the house mark under IBM, and its sub house mark named as product mark. They label it as ThinkPad. And normally, this kind of mark is actually registered, and it is the right value to be used for commercial purposes. So it requires registration federally, especially like in the United States, and it can be put the symbol R partly on meaning registered under certain particular government. TM is a trademark, so basically it is the mark for doing trade for certain symbol or acronym or model. So trademark is basically depend on its nature. It could be generic or it could be descriptive. It could be arbitrary or it's just a fanciful idea. For example, like iPad. iPad actually is just kind of fanciful words. It is pad. If in the common word, it may mean this differently, but in the perspective of Apple Computer Corporation, iPad represent a tablet device, a type of computer which has a bigger panel for user to mark their input. So trademark is very significant for maintaining the traceability of the product in the market that is belonging to a particular organization and company. Trademark in the textbook discussed in the form of Java jacket. So Java jacket is basically an insulator layer for hot drinks. So it is insulating the heat of the hot drinks from the user's hand. So that's why they call it Java jacket. Java is a coffee. It is a jacket, which is this layer. So for customer to enjoy hot coffee, normally they want to hold the cup by at this part so that their hand won't get burned. So that is another trademark by the name of Java jacket. This product, like Java jacket or other insulated kind of cup holder, was actually originated in the hot coffee lawsuit in the United States in 1994. So this this bad incident happened at McDonald drive-through fast restaurant, in which one customer is an old lady by the name of Stella Liebeck. So she drove a car and she decided to driving her car to buy hot coffee drinks. But during that time, this kind of hot coffee drinks, it doesn't have this insulation layer, neither it doesn't have the capping to avoid from flipping over and splashing the hot drink to customer. So it happened to be that she accidentally spilled hot coffee into her lap or into her upper leg part, and it caused severe burn on her upper leg parts. So Stella Layback get a legal counsel, and it was advised that she sued McDonald management for negligence in order to design a product to be suited safely to use by customer. So Layback was injured and hospitalized for 1 week, and she needs to undergo skin grafting. So during the legal battle between Stella Liebeck and McDonald, ultimately the U.S. court awarded winning case to Stella, and Liebeck received compensation as much as 640,000 US dollar in those days. So this is another significant incident or accident that happened that requires a product to be safe or to be used by customer with a reasonable protection or with a reasonable good design in order to protect customer and at the same time also to protect the manufacturer or producer or the company. So ultimately, so McDonald or fast food hot drink are becoming cup like this. So the cup has its notification quotient hot, and the material is made of insulator type, so that the hotness is not directly felt by customer, and it has the capping, and the cap also got some opening for customer to drink. So this kind of design product is relatively safe for customer to handle. If it flips, perhaps it is hardly to spill much hot coffee instead of without the cap. So product offered to customer also evolutionized and tested as it is being experienced by customer as the time passes. So the second category of intellectual property is named as copyright. So the name says to itself, which is the right to copy. So if it is copyrighted, so users third party need to earn the right or get the right from the producer, inventor, in order for them to copy, right? So basically, in Malaysian university, you can see that many books can be easily photocopied because there is a copyright law, but it is not fully enforced. However, in the advanced country like in the United States, UK, this copyright law is strictly monitored and followed. So you cannot bring a book and ask a photocopier shop or photocopy to copy the book for you. So they won't allow it, or they will not do it, because everybody follow the same law, and they strictly follow the rules and guidelines, and respecting the copyright of the author or the producer of the material. Copyright can be in the form of musics, software. It is one way to protect the expression and the expression of the inventor. So default copyright ownership owned by author, right, or by the employee of a company that he or she is working, or through contractor agreement. Open source media, for example, open source software, open source programming code, they are available for sharing in order to build up a bigger software, in order to build up bigger, for example, programming codes. So this is considered open source. Open source means it is free. It is not copyrighted. So it is open for many developers freely, for them to share and for them to build up upon existing building programming codes, right? So the format of copyright is quite flexible. It could be in the form of copyright C, 2010 Google or right reserve, or it could be merely just C within the circle, years, and the company that is copyrighting the media or the material. So this is known as copyrighted material, in which it is not simply free to be copied or duplicated for distribution, especially for commercial purposes. The third type of intellectual property is known as trade secret. Trade secret, it could be like this formulation of the recipe to produce a Coca-Cola drink, and this is of course already becoming public domain because it has been more than 20 years. So public can easily access the recipe of Coca-Cola nowadays in order to produce another brand of Coca-Cola with additional features. Trade secret is actually confidential information that is used for business competitive advantage. The company creating the recipe and the formulation so that they can avoid direct competition by any copycat company. So trade secret actually prevents, but it does not totally block others from developing similar product. At least it may be able to present the right of the first or the pioneering producer of that secret recipe and formulation for the sake of the company. Protection actually provided by either country, the government, or either by the state government. So, and it can last as long as 20 years. So it must be actively worked to protect the trade secret by the company by having this kind of non-disclosure agreement. Is like a documentation of memorandum of understanding or agreement in order to share or release the information of trade secret to other company. So they must have these confidential markings or chop or stamping, and that employee need to be educated to protect their company trade secret, because that is the asset to the company from the competing competitor, or just from the copycats company. Top secret like Coca-Cola. So basically the recipe contains carbonated water, sugar, caramel, code E150D, some phosphoric acid, caffeine flavorings, and also natural flavoring. So this recipe of Coca-Cola has become public, and you can have the actual recipe in terms of content in United States Patent Office. Patent. So the third category of intellectual property is patent. Patent is normally known as limited time monopoly granted by government in exchange for teaching the public new and useful product. Usually patent carries the time range of 20 years from the time it is being filed. So patent is another way to protect inventor or the owner of the invention so that it may limit others from copying the same product bearing different names or different trademark. So patent is highly regarded as a big asset for a company. As I told you that Mercedes-Benz already made some assessment on Proton that it has very low patent content or ownership, and decided that Mercedes-Benz didn't want to cooperate with Proton due to its low patent ownership, and it is considered non it's not good to collaborate with Proton because of its patent issue. So requirement to obtain a patent. In order to patent or not to patent, it is very subjective matter. So it is you who could justify patent office that your invention or your product is novel, useful, or not obvious but useful. So it is you to file the patent application to get your patent right. What is it in a patent? Patent application is a very detailed document stating the very detailed up to measurement, up to material. Actually, it is a very detailed documented product, just like your secret document. In order, you need to submit to patent office in order for them to evaluate and compare with other product, so validate it prior issuance of patent number to your newly invented product. So if you check at www.uspto.gov, so you will go to US Patent Office, so you can check patent, trademark, IP policy, and you can see many patents under United States Office, ranging from new product processes. So it is available for public to use, to study, and to assess. If you want to really use the actual patent for your process and for your new product, then you have to pay some royalty to the owner of the patent, and only then it is legal for you to use its data and information. So patent is actually very high value item. It's a big asset and need to be protected by the owner in order to safeguard it from companies that are looking forward to copy your intellectual property. In Malaysia, patent office is known as MyIPO, Malaysia Intellectual Property Office. You can go to its website, and you can click many patents also available patented by Malaysian inventors at Malaysia IPO, particularly in the Malaysian new invented product. This is a very specific example in the textbook, a patent showing insulated layer for hot drink cups, right? However, the design is made from the corrugated board. So if you go to US Patent Office, you can check this patent number. You can see when it was filed. It was filed in 1993 by inventor named David Coffin Senior, and it is named as recyclable corrugated beverage container and holder. So it was patented in Fayetteville, New York. Right, this is the address. right? And the date, and what are those US patent document related to this Mr. David Coffin coffee cup sleeve with this patent number 5,205,473, which is pointing to David Coffin coffee cup sleeve. And it shows the detail in the next slide. For example, in order to produce that holder or cup holder, so this is their filing content. It must use a corrugated tube. Okay, corrugated tube is actually this one, this part, the corrugated part, right? So for specific part of the corrugated, so it is numbered 100, and it is later explained 100 is what, and 11 is what, 12 is what, the measurement and so on. So corrugated tube use cellulosic material, cellulose. It is partly kind of like a starch material, and there is a first layer, unequal cross-section plane, second opening, and there is a fluting means, fluid liner, bond. These are the very specific construct of the coffee sleeve by Mr. David Coffin. So later is explained the construction of the material with this kind of layer and liner, and there is a marking number that belongs to each material. So how it is constructed, very detailed description of the diagram how to make that sleeve. Figure 6A, so this is the measurement from peak to peak, what is the distance, and this layer 22 means what kind of layer, so it is very specific kind of construct, right? So another patent by inventor J. Sorensen, US patent 5,425,497. So there is another construct of different cup sleeve. Instead of corrugated, they use perhaps foam or foam bubble. So that is another way of producing cup sleeve. Another patent by a different inventor. So basically, patent and business plan are related. So in order for you to make your business plan successful and inventing new product, you need to protect it in the form of patents, because patents will permit you to sell your idea and your invention to other people, so that if other people wanting to use it, they will pay royalty to the inventor or to the company. So obtaining a patent is basically a lot of work, a lot of process, a lot of stages, right? So you need to know what really need to be patented or what not to be patented. So not all new inventions are worth of applying patent. So when to file, right? Basically, where to file also, basically it must go to patent office, right? Like in the United States, patent is patenting for application is basically fast, right, and cheap, and invention protection in the first stage for 1 year, and subsequently it must be renewed. So you need to pay fees in order to have a patent protection, your patent being protected in future. So you need to apply the subsequent renewal. Well, it costs you money to patent your invention. Like as far as United State patent application, it range from 5,000 to 15,000 to prepare the application, and the your filing fee is for another 400 up to 800. So if it needs some prosecution, somebody breach your patent, then the cost is 5,000 to 15,000. Ultimately, you pay for almost 20,000 for patenting your newly product. So it is costly. So of course, companies are very selective of their newly invented product, whether to protect with patent or not. But most big company, they protect their invention by patent office. By that, I would like to close this lecture on patent and intellectual property. I hope this explanation and lecture has been helpful for you in your final exam. And thank you for your attention on listening to my lecture. Thank you again.